Good afternoon, everybody. And my eyes, I think, still work, even though I was spending a lot of the day today reading the motion, looking at the exhibits, and boy, what an undertaking this motion is. And before I even begin, I mean, there is so much to unpack in this motion. It's really voluminous. I mean, it's just there's so much. There's really so much. I mean, you can spend probably 4 or 5 videos of that I do, and I talk pretty quickly and I get through things pretty fast. But you can probably go 4 or 5 videos just breaking down everything in this motion, because like there's just different parts. Each part, there's a K. Peter part. There is a Cosgrove part and a Mello part. There's a Tully part. There is Lindsay Gattani part. I mean, there is just so much in this motion to break down that it's really an undertaking, but we're going to do our best. We're going to absolutely do our best, and we'll see how much we can actually get through today. There we go. Okay, I just got to get rid of this. Give me 1 second. All right. So we got to pull up the motion. We're going to go through actually certain parts of the motion out of order. And there's a reason. There's a method to my madness. There's a reason why I'm going out of order. But I really want to hit some of the real main parts of this motion, legally speaking. There's a lot of background, a lot of information that I personally didn't know about. Maybe Turtleboy was talking about it all these years, but I can't watch every one of his shows. But there's just a lot of information that maybe you did not know or were aware of even. And just getting through that part is really, really eye-opening. So, a lot of the background and factual information that may not necessarily be necessary for the legal argument, I'm not going to at least initially discuss. This may take more than one video. I have a hard stop at some point today. I can't go on all night. So we're going to do our best. Now, I do want to say, first of all, I mean, just reading this motion, you guys know this is what I do for a living, and this is what I do with all of you. I read through these motions, I read through these opinions, and you can immediately tell the skill of Mark Betterow. Not to say anything negative about Tim Bradle. He's also awesome, as we're watching. But, I mean, Mark Betterow in this motion, his style of writing, it's really unique, and it's really strong, because it's not just reading like legal arguments, which can be very boring. It reads very well. It's easy to read. That's what I was kind of tweeting out before, how much easier it is to read. Now, it's a lot. You got to read through it, but some good books also take a long time to read, but they just have your attention. So for a lawyer like me, which I read a lot of opinions and a lot of motions, and, you start to see the difference. And it's just a work of art. It's really, I wonder how long he worked on this for, because it's really just a work of art. And you see the snark come out. Somebody mentioned that maybe I should be Snark Daddy, because I got a little snarky sometimes. And if I had to battle it out with Mark, he may have one over me on this. So if he's not claiming the rights to that title, I may, because I like it. Snark Daddy, not bad. Okay, so let's get right to it. We'll pull up the motion, and we'll go through it. So let me just share the screen so you can see what I'm talking about here. And also, something that's very nice about this motion, before we even get into the actual details of the motion, there is links in this motion, which make it also so much easier to read, because a lot of times you'll have exhibits, and especially in a filing like this, when you have multiple exhibits. I didn't count how many exhibits there are, and I didn't see the index of exhibits, which was filed, by the way, in case you want to see the index, but I didn't see it on this that I got. When you have a lot of exhibits in a motion, it's hard to kind of flip back and forth all the time between the exhibits. And here, Mark Betterow and his firm, what they do is they have a link right in the body of it, so you can just click on that link and get straight to the exhibit, which is really nice, because as you're reading, just click the exhibit, you see exactly what he's talking about, and you can go right back to reading the document. So it's just great. So we're going to start off with this part, the flawed grand jury presentation, because really this is the crux of this motion to dismiss. Now, there's also other parts of this motion, the motion to disqualify, But the crux of the motion to dismiss is that the grand jury presentation was false. There's also other issues, which there's another, I should say this is not the only crux of the motion, but one of the main ones is the fact that the grand jury presentation was flawed. Okay, so let's start with this. We'll see how long we go. And you can put your questions, and we'll try to get to some of your questions as well. So here we go. The grand jury proceeding commenced on November 28th, 2023, and continued December 5th, December 14th, December 19th, and December 20th, 2023. The main witness against Mr. Carney was Detective Lieutenant Tully. Now, we're going to refer to him as T for short, so we don't have to keep saying Detective Lieutenant Tully. So we'll just call him T. All right. So the main witness against Mr. Carney was T. He testified a total of 11 times over the course of the 5-day proceeding. He was their star witness. On December 20th, 2023, the grand jury voted to indict Mr. Carney for witness intimidation. I don't know why they don't call him doctor, but that's none of my business. Maybe you can make another motion about that. All right. So on December 2023, the grand jury voted to indict Mr. Carney for witness intimidation, picketing, and conspiracy to commit witness intimidation. Mr. Mello did not seek Mr. Carney's indictment for illegally wiretapping Mr. Scanlon. Now, if you know something about Mr. Scanlon, this is what I learned about in this motion. Could be if you were following Turtleboy, you already know about Mr. Scanlon. But Mr. Scanlon was a private investigator, apparently, who contacted Karen Reed, who then put him in touch with David Yannetti. They had a meeting initially. He was going to do some work. Maybe he was going to get paid, not get paid. He gave back a check, whatever the point is. He spoke to, at some point, Turtleboy. So he spoke to Aiden. And that was recorded. It was recorded, and it's part of this motion, actually. We're not going to play the recording because it's like an 8-9 minute recording, and I don't want to waste time here. But there is a recording that you could get if you have this motion, and it's in the link, and you can see the recording. So, and I'm not going to just keep saying maybe Turtleboy already played this, because it could be he did, and I just don't know. So just assume that I always say that anytime we're talking about this additional information that many of us didn't know before. So what happened here is that Mr. Mello eventually did not seek to indict Turtleboy for the illegally wiretapping of Mr. Scanlon. Now, there's an allegation here that Turtleboy recorded that conversation. And if not a lot of recorded conversation unless you have the consent, right? Which is why there was another issue with this when Turtleboy was on camera right in front of D&E, right? That was without his consent. So there's this law in Massachusetts. Both sides have to consent before you have a recording. So the allegations were at some point that Turtleboy recorded Mr. Scanlon on this phone, on this line. And Kate Peter got a hold of this recording and sent it or forwarded it to Tully, to T. And this is part of what their presentation to the grand jury was. Now, we're going to see why that's a real problem if you don't end up indicting Turtleboy on wiretapping. If you're not going to indict him on something, you can't just present negative things about the defendant that have nothing to do with the charge that you're going for. There's a big problem with that. So, again, let's go through this. Mr. Mello did not seek Mr. Carney's indictment for illegally wiretapping Mr. Scanlon. And by the way, I will say something also, and that is that part of this recording, this may come out in the motion as we're reading it, but part of this recording with Mr. Scanlon is that he claimed that Turtleboy said to him that he's not going to record it. Now, on the recording itself, it starts very obviously in the middle of the recording. I'm not sure who has the full recording of this, but it starts in the middle apparently. And you don't hear any conversation about whether it's going to be recorded or not. So I don't know if Turtleboy's position is that we both agree that it would be recorded. I'm not sure. But you don't hear, at least I didn't from the beginning of the conversation, and therefore you may not hear any conversation about whether it's going to be recorded or not. Continuing. All the evidence Mr. Mello presented on November 28th, 2023 related to the uncharged allegation of Mr. Carney illegally recording of a phone call with Mr. Scanlon. So November 28th, 2023 was devoted to this issue of recording Mr. Scanlon talking to Aiden Carney, which he never ended up indicting him on. So the whole full day, I don't know how long they go on this day, November 28th, but the entire day was spent, which was going to be an uncharged allegation, which he was never indicted on. And there's a big problem with that. The evidence presented in support of the uncharged allegation of wiretapping consisted of the partial recording Ms. Peters sent T and testimony from Mr. Scanlon. T and Sergeant Buchanan, who simply read a hearsay interview report into evidence. So this is the report that Buchanan took from Mr. Scanlon. So he met with Mr. Scanlon and he took a report. So he read this report to the grand jury. Now, there's nothing essentially wrong with the presentation of hearsay evidence to a grand jury. You are allowed to do that. But again, he's just laying out, Mark Better was laying out what happened on that day. It's all devoted to this recording, this illegal recording of Mr. Scanlon, allegedly illegal recording. And this was sent, of course, and that's a common theme throughout this entire motion is the fact that Kate Peter is sending all this stuff, feeding all this information to Tully. And she's a very actively part of this investigation, which again is another problem, maybe for a different day. We'll see if we get to it, but that's another problem. But we have to isolate the different problems with what happened here. And there's a lot of them. The illegal recording, in quotations, played before the grand jury didn't start recording until 1:09 into the call between Mr. Carney and Mr. Scanlon. So yeah, see, it did not start until 1:09 into the call. Mr. Scanlon claimed that during the non-recorded portion of the audio played before the grand jury, Mr. Carney told him that he wouldn't record their conversation. So there you go. Mr. Scanlon claimed that, oh yeah, before that recording, which we don't have, of course, coincidentally, in the non-recorded portion, that's when Dr. Turtleboy said that they're not going to record the conversation. Mr. Mello didn't authenticate or otherwise demonstrate the reliability of the partial recording provided to him by Ms. Peter. How do we know that this is actual real conversation? Who's going to authenticate that? No, we'll just take her word for it. Mr. Mello didn't instruct the grand jury about the purported relevance of the wiretapping evidence. So when you're in the grand jury proceeding, the prosecutor plays a very important role, very integral role, but he didn't tell the grand jury about what the relevance is of the wiretapping evidence. Mr. Mello didn't instruct the grand jury to disregard any bad act evidence or instruct the grand jury about the wiretapping evidence when considering the charges presented for its deliberation. You're not allowed to present to the grand jury, oh, this guy's a terrible guy. You know why? Because he did A, B, C, D, E, F, G. And by the way, we're going to indict him on something completely different. You're not allowed to do that, obviously. It's pretty intuitive, but there's also the law is right out straight about that. What Mr. Mello did do was instruct T to read to the grand jury the text of the wiretapping statute, including its possible punishment of 5 years imprisonment. Okay, there is right there a huge problem. You are not allowed, and this is clear. It's like clear in the law. If he did this, this is straight out of violation. That you are not allowed to tell the grand jury about the possible punishments for what you are intending to indict this person on. You're not allowed to do that. It's not part of the grand jury proceeding. Nevertheless, Tully read to the grand jury this part of the statute which talks about the punishment. At the conclusion of the November 28, 2023 session, Mr. Mello informed the grand jury that this case involved a violation of that statute, after which he summarized the definition of the wiretapping statute, which meant the grand jury heard it twice that day. So this is what, right, at the conclusion, he's informing the grand jury that this is a case involving a wiretapping violation, right? And then at the end of everything, he doesn't indict him at that at all. Doesn't even bring that charge. After he drops it. After November 28, 2023, Mr. Mello never referred to the wiretapping allegation again in the grand jury proceeding. So this is how they started off. Now, think about this if this is calculated. Okay, just you have to use some of your common sense. Why would they do this? Why do they do it in the first day on a charge that they're not even going to end up charging? So to smear his character. Very obviously, they want to present this information in front of the jury so they can already get a bad taste about who this guy, Dr. Turtleboy, is. All right. So on September 11th, 2025, I was informed, so skipping ahead a few years, on September 11th, 2025, I was informed by Mr. Cosgrove that Mr. Mello decided not to proceed with a request for the grand jury to indict Mr. Carney for allegedly wiretapping Mr. Scanlon. So yeah, he decided we're not going to proceed with that request from the grand jury. On information and belief, if Mr. Mello decided not to seek a wiretapping indictment after November 28, 2023, then he realized that the audio recording Ms. Peter gave to Tully wasn't reliable evidence. Why else would he not indict him? It's open and shut. Right? It's pretty clear. He's recording him on a line. He got Scanlon saying that he never agreed to it. There's no consent. He said, in fact, that it was not going to be recorded. So what's the issue? But he decided not to indict him. There were no other logical reasons for Mr. Mello to call 3 witnesses, introduce the recording, and introduce a hearsay report in support of a wiretapping indictment and not seek an indictment unless he, A, realized that the evidence wasn't reliable, or B, he offered the evidence exclusively for the purpose of prejudicing Mr. Carney before the grand jury deliberated on the submitted charges. It's only one of those two. Either he realized at some point that it wasn't reliable evidence, or he wanted to smear Turtleboy before he started with the witness intimidation charges. Which one is it? Either one is not good. As the legal advisor to the grand jury, Mr. Mello knew, or should have known, that he should have decided to not proceed with seeking an indictment for a serious crime before he severely prejudiced Mr. Carney by calling witnesses, playing a recording, and twice instructing the grand jury on the elements of, and once on the punishment associated with his clear violation, the uncharged wiretapping allegation. So get your stuff together, which is an issue for Mr. Mello. Get your stuff together before you are going to decide whether you're going to introduce this evidence to the grand jury and then decide you're not going to charge him. As the legal advisor to the grand jury, Mr. Mello knew, or should have known, that if he decided not to seek Mr. Carney's indictment for wiretapping after he presented voluminous evidence in support of that uncharged crime, at a minimum, he was obligated to instruct the grand jury that A, it must disregard all evidence in support of that uncharged bad act, and B, it may not consider that evidence as proof of Mr. Carney's bad character. C, it must disregard all legal instructions provided about the charge, including any possible prison sentence, and D, it may not consider any of the evidence presented on November 28, 2023, in considering the submitted charges. Mr. Mello didn't provide any of the instructions, which means if you start off the grand jury with a whole day full of evidence of a charge, which you eventually decide in the middle of the grand jury proceedings, we're not going to charge him with this. Well, then you have to give a curative instruction. We've all heard about curative instructions. Now, we're more used to trials, and it's very different, grand jury from trials. We understand that. But still, the prosecutor has a duty to, if you're not going to charge with all this evidence that you spent an entire day putting on in front of the grand jury, then you have to instruct them not to take any of this evidence into consideration at all, and not to consider it as a bad act, not consider it as proof of his bad character, and to disregard the instructions about it, and to disregard the prison time that was suggested also, or is possible, and none of that was done. So why did you do it? Okay. Without more, Mr. Mello's presentation of irrelevant and prejudicial evidence of an uncharged bad act that bore no relationship to the charges before the grand jury impaired the integrity of the grand jury proceeding. And here he has a case right here, Commonwealth versus Brown, where you have intentional admission of a prior bad act without curative instruction may impair integrity of grand jury proceeding. It's not the greatest language of must or automatically, but if there's not a good reason, then the court could find that it impaired the integrity of the grand jury proceeding, which there's a very strong argument to be made in this case. That's how you started off with all the stuff, all this evidence that you're not even going to indict him on, and then talk about other charges. Most of the evidence Mr. Mello offered in support of charges that he actually presented for the grand jury's consideration consisted of what he and Tully knew were cherry-picked out of context snippets from Mr. Carney's online content. And this is where we hear about the snippets, that they just cut some of the bad parts, or what sound very bad, of his YouTube shows, his 3-hour YouTube shows. So you take 30 seconds of it here, 30 seconds of it there, it can sound really bad. But if you take the full context of it, then you can have a different impression, which is important for a grand jury proceeding. You're not allowed as a prosecutor just to take certain parts of the statements out of context and present it to the grand jury. Now, do that. The critical issue for the grand jury's determination regarding the witness intimidation charges was Mr. Carney's intent, right? This is, as I've been saying all along, when it comes to witness intimidation charges, it's not about whether Turtleboy acted like a jerk and loud and got on the megaphone and started screaming about his theory of the case and saying, tell the truth. It's not about that. The question always hinges, when it comes to witness intimidation, about the intent of your actions. What was the intent of his actions? Was he intending to be an activist and get a rally together? Was that his intent? Or was his intent to specifically intimidate the witnesses? That's a very hard question to answer. How do you know what someone's thinking at the time? So That is the ultimate question. Okay. And that's a very important part about this. The ultimate question for the grand jury, no one is allowed to give an opinion about. The same way that we have in trial. We've heard about this in real trials, like not grand jury proceedings, but in trials, we know that very often it's a question about experts, but you're not allowed to give an opinion on an ultimate issue, an issue that's going to be in front of the jury. That's called invading the province of the jury. So again, the critical issue for the grand jury's determination regarding the witness intimidation charges was Mr. Carney's intent. Mr. Mello improperly expressed his unsworn opinion that Mr. Carney intended to intimidate witnesses. So that's his own opinion. Now, Mr. Mello is definitely not allowed to give an opinion. First of all, he's not a witness, or supposedly not a witness, which is also another problem we're going to see in this motion, whether Mr. Mello is actually considered a witness now. But even if he's not a witness, as a prosecutor, you're not allowed to say to the grand jury, well, it's not a closing argument. You don't get to say, this is the presentation of the evidence, and therefore I believe that I've proven my case that this person committed this charge. You're not allowed to do that at a grand jury. That's for trial. Grand jury, all you're allowed to do is present the facts, present the evidence, and that's it. Leave it up to the grand jury to decide. So here, the allegation is that Mr. Mello actually, and we're going to see the exact quote soon, actually expressed his unsworn opinion that Turtleboy intended to intimidate a witness. If he would have done that straight out, again, that's a straight out violation. Not allowed to do that. Mr. Mello improperly elicited Tully's opinion. So not only did he do this on his own, Mr. Mello, and again, these are what he's saying here, but also Tully, when Tully was on the stand and he was asked by Mr. Mello for his opinion that Mr. Carney's intended to intimidate witnesses. Mr. Mello improperly elicited from Mrs. McCabe, Matthew McCabe, and Ms. Nagel their opinions of Mr. Carney's intent. Another problem. You asked these civilian witnesses, can they give an opinion about Mr. Carney's intent? First of all, it's very difficult to say what somebody else is thinking, right, at the time. But the question was asked. And again, we don't get to see the exact transcript of the grand jury. But if they were asked their opinion of his intent, that's also improper. Like textbook improper. Now, police officers are allowed to give certain opinion testimony, but any opinion that has to do with an ultimate decision that the grand jury has to make, that is an opinion that you're not allowed to give. You're not allowed to ask for or elicit if you're the prosecutor. If it's an ultimate issue, this is what the grand jury is here for. You're not allowed to tell them or ask witnesses, yeah, we think that there's intent here, or we think he's guilty. Not allowed to do that. Mr. Mello and Tully deliberately misled the grand jury by giving it the false impression that Mr. Carney named his episodes in a manner suggestive of his intent to intimidate witnesses. And this is what we heard about a little while ago. And as soon as I heard about this, that the titles of his show were changed and presented to the jury in that manner, that directly also is a clear violation. You're manipulating the grand jury. 14 times during the grand jury proceeding, Tully improperly testified that the grand jury exhibits were maintained in a folder titled Intent. Okay, so not only did they change the titles, but they kept all of these exhibits, all of his videos or clips from the videos, in a folder called Intent. And they refer to it as, oh yeah, sure, we'll Tully's on the stand. So then, Mello would ask him again. I don't know exactly this is how it happened, but this is presumably something similar to this, where Mr. Mello would ask him, okay, well, what about the next video? And Tully would say, yeah, well, I'll just go to the folder named Intent, and we'll pull it out from this folder Intent, and then we'll see what the Intent folder has to say, and we'll see what's in the Intent folder, and Intent, and all this evidence is in the Intent folder, showing that he had intended to intimidate these witnesses. You can see the problem here. Again, invading the province of the jury here. So 14 times. That was 14 times that he got out of the folder titled Intent. Mr. Mello and Tully concealed from the grand jury that Tully, not Mr. Carney, created and named the Intent folder, and that Tully, not Mr. Carney, renamed the clips Tully edited from Mr. Carney's actual episodes. So Tully renamed the clips and put them in a folder Intent. Carney didn't do that. Turtleboy didn't do that. This wasn't a folder of Turtleboys named Intent. He's not that dumb. He wouldn't say, I'm going to have a folder of intent, how I'm going to intend to intimidate witnesses. No one's that dumb, right? But Tully did. I mean, he did it because this is what his folder of intent is, where he may feel there's evidence of intent. Doesn't matter. You're not allowed to say that to the grand jury, that you're going to the folder of intent and look at all these videos that we have in the folder of intent, and then talk about how the titles of the video are a lot worse than what Turtleboy named them. And we're going to see soon this the table of it. It's unbelievable how many YouTube videos they renamed. You'll see in a minute. Mr. Mello neither instructed the grand jury to disregard Tully's repeated reference to retrieving videos from the intent folder names, nor told the grand jury that it was the exclusive fact finder on the question of Mr. Carney's intent. Meaning, let's say Tully did this by accident for 14 times. Let's say he by accident did this 14 times. Well, then, as the prosecutor, if you want this to be a fair proceeding and not have motions like this, then what you should do is instruct the grand jury, please disregard anything that this witness had to say about intent. You are the sole fact finders about whether there was intent here. After being peppered with improper opinions that Mr. Carney's intended to intimidate witnesses, the grand jury was left to speculate and likely incorrectly believe that Mr. Carney, not Tully, created the intent folder. If the grand jury knew that the intent folder, the episode names described to it, and the edited clips that became the grand jury exhibits all were created by Tully instead of Mr. Carney, the probable impact of such evidence would have been substantially less. If the jury thinks that these are all folders that Carney created, they can think that he's a real sinister guy. He really created this folder intent, and he named these clips the way that Tully named them, and actually said these things completely out of context, which was presented to the grand jury. Well, then, yeah, they can think that this guy Turtleboy really is up to no good. And really, he did intend on intimidating witnesses. But if the grand jury would have known that, no, this was Tully doing, well, then maybe they would have had a different outcome. Either way, and again, that doesn't really matter whether Tully was the one who named it intent or if Turtleboy would name intent. Even if Turtleboy didn't name an intent, and that was clear, still, either way, by repeatedly encouraging Tully to testify that the edited videos offered to prove Mr. Carney's intent were maintained in a folder named intent, Mr. Mello intentionally and improperly bolstered the distorted evidence because Tully's testimony was tantamount to additional expressions of Mr. Mello's and Tully's opinion that Mr. Carney's intent was to intimidate witnesses. Again, if you mention the word of intent, you got to be very careful. And if you mention it 14 times, that smells like something else is going on. Mr. Mello and Tully further deceived the grand jury by playing edits of Mr. Carney's lengthy episodes and then depriving the grand jury from the complete and accurate context contained in his actual episodes. And there's some case law on this also where you can't take statements out of context and just show those statements to the jury, to the grand jury. Can't do that. And Turbo's got these 3-hour shows. So yeah, maybe you have to say, maybe you actually have to make the grand jury sit through all the shows. Maybe, or at least, at the very least, the context for what he's talking about, right? His show is split up into different things. First, he's talking about this topic, then the next topic. So whatever topic you choose to talk about to the grand jury, well, then you got to play the entire section. This sleight of hand dramatically misrepresented the context of the episodes and their names and deprived the grand jury of the right to the complete statements made by Mr. Carney, see Commonwealth versus Mayfield. Failure to disclose known information may impair the grand jury proceeding. And here again, prosecution's introduction. Okay, so some more case law that also bolsters that allegation. The cumulative impact of Mr. Mello's concealment of the actual titles, length, and full content of Mr. Carney's episodes deliberately kept the grand jury ignorant of the truth. Mr. Carney's mostly hours-long episodes were dedicated to subjects far different than the edits and names Ms. Peter provided to Mr. Mello and Tully, and included elements of comedy and satire. Believe it or not, Turtleboy actually has some parts of his show which would be classified as satire. As detailed in the following chart, the Commonwealth engaged in pervasive misconduct by repeatedly misleading the grand jury about Mr. Carney's episodes. Now, we're going to get back to the footnote because you guys know how much I like footnotes, but look at this. Look at this chart. It's not just 1 or 2 or 3. Look how many were changed. I mean, even Jennifer McKay may think that something is nefarious at this point. Look at this. 29 different clips that they completely changed the titles to. And some of them, I mean, all of them are worse, right? enjoying what witnesses squirm. I do not want this to go to trial when the real episode is called Colin Albert drops out of school. Brian Higgins flipping is the end near. So, yeah, maybe this is you, Tully, trying to organize your own file in that way. And so this will help you, but you can't present it to the grand jury like this. Completely improper. And to say that this was just one mistake, it was one, one day I just wanted to quickly, I was going to come back to it and rename it the right way, but, but when there's 29 of them, that argument doesn't fly. Now take a look at this footnote here. Mr. Mello and Tully schemed to mislead grand jury with evidence that Mr. Carney's episodes' names were indicative of his criminal intent, even misled the court and Mr. Cosgrove. In sustaining a number of the witnesses' intimidation counts, the court in its May 19th, 2025 decision, so this was, remember, there was a initial motion to dismiss that was filed that was granted in part and denied in part, right? Proctor got out, they got Proctor out, they got Buchanan out, because Buchanan was terrified, absolutely terrified when he gave Turtleboy the finger. He was quaking in his boots there. Okay, but anyway, so that was dismissed, and Proctor was, but everybody else was state. So that wasn't dismissed. But even in that opinion, in sustaining a number of the witness intimidation counts, the court in its May 19, 2025 decision understandably referenced the episodes by the false names provided by Mr. Mello and Tully in a manner suggesting it believed the names were created by Mr. Carney and were relevant to its decision. So the court in its decision referenced these episodes by the title that Tully gave them, which would even suggest that the court was confused about who actually wrote these titles, and the court was assuming that Turtleboy actually called these episodes what they were, that what they were presented in court, and it wasn't even true. So they even misled this court. In a July 29, 2025 filing, Mr. Cosgrove, also apparently unaware that Mr. Mello and Tully distorted the evidence in reference to Mr. Carney's intent, cited the aptly titled episode 616, trying to destroy Colin's life, when in fact that episode is named Karen Reed's Case, Commonwealth Tells More Lies About John O'Keefe's GPS Data. Which sounds worse, by the way? Which sounds worse? Trying to destroy Colin's life, or Karen Reed Case, Commonwealth Tells More Lies About John O'Keefe's GPS Data? Okay, so let's continue. And this is unbelievable. I mean, this chart in itself, should be enough to dismiss. And this was presented to the grand jury like this. Let's move on. The above chart and Mr. Mello's conduct on December 20th, 2023, immediately before he sought Mr. Carney's indictment, best demonstrates how he repeatedly impaired the integrity of the grand jury proceeding and prejudiced Mr. Carney by misleading the grand jury about the evidence of Mr. Carney's intent. Prior to December 20th, 2023, Mr. Mello already had spent an extraordinary amount of time and effort introducing inflammatory and irrelevant evidence and instructions related to an uncharged bad act, referring to the first instance of Turtleboy and Scanlon. Prior to December 20th, 2023, Tully already had falsely and improperly testified about the location, names, length, and content of at least 17 edits from Mr. Carney's episodes. And you look at the chart. Prior to December 20th, 2022, Mr. Mello already had bolstered his improper presentation of evidence by eliciting Tully's affirmative statement that, look at this is the statement, this is the quote, these incidents, meaning the videos previously played, were all attempts to intimidate these witnesses. That's what Tully said. Is that an opinion? Yes, of course that's an opinion. Is it an opinion about an ultimate fact that only the jury should decide? Yes, very clearly, because the only issue is, when it comes to witness intimidation charges, is intent. And he's saying, yes, this is his verdict. You're telling the jury what you believe the verdict should be, even in the grand jury proceedings. On December 20th, 2023, Mr. Mello bolstered his previous misconduct with his unsworn opinion and Tully's sworn opinion by eliciting Tully's agreement with him that edited exhibits depicted Aidan Carney's making some comments about his intentions with respect to his activities. So he's making some comments. This is a quote apparently from Mello, getting Tully to agree with him that he was making some comments about his intentions with respect to his activities. So again, that's getting into the opinion area, which a prosecutor is not allowed to go. Immediately following this improper marshaling and bolstering of the edited evidence, Mr. Mello instructed Tully to play the videos, which he just told the grand jury he and Tully believed proved Mr. Carney's intent. So he said, okay, so all these videos that are in the intent file, are these comments that Turtleboy made about his intentions with respect to his activities? And the answer to that was yes. Okay, let's play the videos about his intentions from the intent folder, about his intentions to intimidate witnesses. Let's play that for the grand jury now. I mean, obviously, what are you doing? Tully proceeded to play a series of videos which he, again, improperly testified it came from the intent folder, as I guessed. As they did 17 times previously over the past 3 sessions, Mr. Mello and Tully intentionally misrepresented the names of Mr. Carney's episodes to make them sound consistent with what they told the grand jury was Mr. Carney's criminal intent, and then Tully played out of context, cherry-picked snippets, while Mr. Mello deprived the grand jury of the full context and accurate names of Mr. Carney's episodes. So then he would say, all right, now play I want to make Colin Albert's life miserable. Play that one now. And now play the one from the intent folder that says, I want to intimidate Brian Albert. I mean, these aren't exact names, but this is the idea for all those 29 episodes. 29 clips, I should say. Well, they are 29 episodes also. Okay. Anyway, Tully matter-of-factly falsely swore that among Mr. Carney's episodes from the intent folder were episodes he prejudicially named, such as enjoying watching witnesses squirm, trying to destroy Colin's life, and no right to leave peacefully. As if Mr. Mello and Tully's conduct already wasn't bad enough, they exacerbated the prejudice to Mr. Carney by further bolstering the evidence and their improper opinions of it by replaying edited videos and repeating their false names for videos, even though they already had been presented to the grand jury. So they kept doing it. Specifically on December 20th, 2023, Mr. Mello replayed the following misnamed and misleading episodes. In case one wasn't enough, they replayed it again. Trying to destroy Colin Albert's life. Life as normal is over. Albert should be afraid. That sounds like witness intimidation, but Turtleboy never named it that. No members of the O'Keefe family testified before the grand jury. Mr. Mello didn't seek Mr. Carney's indictment for the alleged witness intimidation of any members of Mr. O'Keefe's family. Tully testified that the final video played in the grand jury presentation came from the intent folder and was entitled Rolling Rally, Don't Feel Bad for the O'Keefes. Tully explained that the final video's name referred to the parents and family of John O'Keefe. The length of the actual video made by Mr. Carney was 2 hours and 8 seconds. So he played 58 seconds in length. So he played 58 seconds for the jury, but the entire video was 2 hours and 8 minutes. Now, we're not saying that you have to play the entire video. Like I just said, you don't have to play the entire video. I'm sure Turtleboy would appreciate that, let them all see my entire show. But that's not what you need to show. You have to just show as at least the full context. That's all you have to show. The actual title of the video made by Mr. Carney was Canton, the Justice for Karen Reed and John O'Keefe Rolling Rally. As the title and content of the actual video made by Mr. Carney demonstrates, the grand jury was misled and deprived of evidence that in addition to Miss Reed, Mr. Carney stated he was seeking justice from Mr. O'Keefe. So we all want justice for John O'Keefe, right? Everyone wants justice for John O'Keefe. Just because you saw the evidence and saw the trial and realized that Karen Reed was supposed to be not guilty doesn't mean you don't want justice for John O'Keefe. The small clip of the misnamed video was irrelevant to the charges before the grand jury because it wasn't offered in support of allegations that Mr. Carney had intimidated anyone from Mr. O'Keefe's family. Why are they playing something about Mr. O'Keefe's family? Is there any allegations that Turtleboy was trying to intimidate anybody in the O'Keefe family? No. So what are you doing that for? Well, maybe to show that bad acts, bad character. Mr. Carney's brief discussion of the O'Keefe centers on his frustration that they have been misled about who was responsible for Mr. O'Keefe's death and the impact their belief had on Ms. Reed, which I think a lot of people on the Free Karen Reed movement believe that they feel very bad. They actually do feel bad for the O'Keefe family that they were misled by the Commonwealth and the prosecution in this case. And your heart can go out to them if they actually complete and put their full faith in this prosecution. And we all saw it. It's sad for the victim's family. The final clip constituted another example of Mr. Mello improperly introducing uncharged bad acts evidence to prejudice Mr. Carney, to prejudice Mr. Carney and to appeal to the emotions of the grand jury. Mr. Mello did not instruct the grand jury on the purported relevance of the final edited exhibit or caution the grand jury to limit its deliberations to relevant evidence. Meaning, if you're going to play something that which you realize, oops, shouldn't have done that, then give it cautionary instruction. Like we always see in trials. You give a special instruction to the jury. Say, okay, whoops, we made a mistake here. Just don't consider that. At the conclusion of Tully's December 20th, 2023 testimony, just as he did immediately before Tully testified, Mr. Mello informed the grand jury that he had presented it with sufficient proof of Mr. Carney's intent to intimidate witnesses. So now look at this. Look at the quote here. Okay, this is from Mello in the grand jury proceeding. And this is what he says. Now, he's talking to the grand jury. Now, to prove intent, the Commonwealth has to prove the purpose or objective of any behavior of the defendant, which would be Mr. Carney. Obviously, it is impossible to look directly into his mind, but we believe that evidence has been presented to you that would allow you to make that determination. Mr. Mello asked Tully if the video depicts Mr. Carney making comments about his intentions. Mello asked Tully if it's your contention that incidents in the video clips were all attempts to intimidate these witnesses, to which Detective Tully replied, yes. Now, this specific statement, I can hear why there can be an argument that this is not telling the jury that your opinion is that there is intent. I can see how you can try to squeeze it and say, no, what we're saying is that we've presented evidence for you to make a determination one way or the other. Not that we've presented evidence to you to show that he didn't absolutely intend on this. But again, you have to look at everything in context also. But just looking at this, and I can already hear the argument that, no, all I was saying was that we believe that you have enough evidence to make a determination as to what his intent was one way or the other, whether he did or did not have intent. You have all the evidence in front of you, essentially. But there can be other, from the totality of everything going on, you can certainly understand that, no, what he was saying was just the opposite, that we presented enough evidence to you that there is intent here. Okay. We're just trying to present what the argument from the other side can possibly be. Throughout the grand jury proceeding, Mr. Mello engaged in other improper conduct that, combined with the above-cited examples, had the cumulative impact of impairing the integrity of the grand jury proceeding, including allowing grand jurors with a strong opinion about Mr. Carney to decide for themselves whether they felt comfortable and telling them they were welcome to stay. So there was a grand juror who said that they have a strong opinion about Mr. Carney. Well, if somebody has a strong opinion about a client because they know him, well, then maybe that person shouldn't be a grand juror. But Mr. Mello said, nah, it's fine. You can have your strong opinion. You can still be objective and fair, right? Instead of instructing them to recuse themselves from this matter. So that was another issue. Another issue, informing the grand jury of sentencing possibilities for charged and uncharged crimes, which we spoke about, repeatedly asking witnesses their opinion, which we spoke about, referring to Mr. Carney's followers as his minions, and expressing confidence. Why would you refer to someone like that? Is it a complimentary way to refer to someone, or are you trying to enrage the jury? Trying to get the jury against this person? And again, it's not a closing argument. That's not what you're allowed to do. This is not a regular trial where at some point the prosecution can argue their case. All right. So before we move on for a moment. Okay. So let's move on. Just wanted to check something, but okay. All right. So that is obviously a very strong basis for the motion to dismiss, because the grand jury proceedings obviously were not fair. By presenting that type of evidence to the grand jury, it wasn't fair. And you're impairing the proceedings. You're invading the provinces of the grand jury. You're giving Tully's giving opinions about what they think they should find, presenting information without giving them curative instructions, renaming what these clips, the videos were. I mean, all the things that we just went through, very, very strong basis for the dismissal. Now, this is where it gets even more interesting. Okay, so the defense's specific demands for evidence. And we're going to go through some of this, which talks about the discovery issues that they've gotten in this case. They just couldn't get discovery. No matter how much they asked, they couldn't get discovery. And then we're going to find out some things about Mello that maybe you did not know before. And we're going to pull it up for you also. On February 23rd, 2021, was that 2021 or 2024? 2024, sorry. The defense demanded from Mr. Mello, among other things, statements made by possible witnesses to Tully. Who could have made statements to Tully? Can anybody think of anybody? Well, how about K. Peter? So they wanted any statements made by possible witnesses to Tully, all statements between or among any civilian witnesses, police, or prosecutors, and material subject to disclosure under Rule 14, including report statements and video. I'm sorry, did I say possible witnesses? Okay, witnesses would not arguably not be Kate Peter. But let's move on. You'll see in a moment. They did ask for statements from Kate Peter. On March 19, 2024, the defense informed the Commonwealth that Mr. Mello's response to the February 23rd, 2024 demand was inadequate and that he had failed to disclose all automatic discovery. So, sorry, Mr. Mello, you haven't complied with your Rule 14 obligations. And this is automatic discovery. On April 23rd, 2024, going through the timeline here, Mr. Mello was directed by the court to disclose all automatic discovery under Rule 14. When? By May 8th, 2024. Mr. Mello did not comply with the May 8th, 2024 deadline to disclose all discovery to the defense. On information and belief, around the time of the court issued the discovery deadline, Mr. Cosgrove joined the prosecution team. So now we have Mr. Cosgrove joining the prosecution teams. Let me just finish this before we get to... Oh, okay. So now take a look at this footnote. Mr. Mello's failure to comply with the court-ordered deadline wasn't the first time he has neglected important legal matters. He has been disciplined for neglecting at least 3 matters. In 2016, he was publicly reprimanded for performing very little work of substance. So now we're going to pull up this reprimand because, like I said, all you got to do is click that link and you can pull up the reprimand. You guys want to see it, or should we just move on? I think you guys want to see it. So let's pull it up. Here we go. Okay. So this is the public reprimand that relates to Ken Mello. And this was in 2016. And this is what it says. As set forth below, it's not too long. As set forth below, the respondent received a public reprimand for neglecting the interests of 2 clients in unrelated matters. In the first case, the respondent was retained by a client to file and prosecute a personal injury action. Over the next 3 years, the respondent performed very little work of substance on the case. With the statute of limitations looming, I guess in Massachusetts it's also 3 years, with the statute of limitations looming, he did file a complaint in the Superior Court. However, a judgment nisi followed because the complaint failed to allege damages in excess of $25,000 as required by the statute, which is also, by the way, the same way in Michigan. You want to file a complaint for personal injury in the circuit court, you have to write in the complaint that you are alleging at least or more than $25,000. The respondent did not advise his client of the judgment nisi or take any other action in response to it. As a result, the lawsuit was dismissed without prejudice. The respondent never informed his client of the dismissal. The client ultimately contacted the court on her own and learned of the dismissal for the first time. In summary, the respondent's incompetence, representation of his client, his failure to pursue the lawsuit resulting in its dismissal, and his failure to inform his client of the dismissal violated these rules of professional conduct. Well, let's see the second case. In the second case, the respondent was retained by a client to represent him in a criminal matter pending against him in the Superior Court. The matter went to trial. Let me take a little drink here. All right. The matter went to trial, after which the client was convicted and sentenced to prison. The respondent timely advised the client of his possible appellate options. He also informed the client that he needed to obtain new counsel for any appeal. He did not, however, return the client's file in order to enable him to pursue the appeal himself or retain other counsel. The respondent also failed to file a notice of appeal for the client or to withdraw from the case, contrary to the requirements of Rule 65 of the Superior Court, which provides that the defendant's counsel in a criminal case that has gone to trial is responsible for perfecting and prosecuting the appeal unless counsel is relieved of the responsibility after a hearing on the motion to withdraw. The client later demanded the return of his files, but the respondent did not comply until bar counsel opened an investigation into the issue. So the client asked for his file back, and he said, I'm not going to give you the file because, after all, it's your file, so why should I give it to you? In summary, the respondent's failure to file a notice of appeal or alternatively obtain the allowance of a motion to withdraw and be promptly return his client's files violated Massachusetts Rule of Professional Conduct 1.3 and 1.6 and D. Okay. And so he got reprimanded. So this is not the first time that Mello has had issues with complying with his obligations. And that is what Federal is pointing out here. And, you're always crossing a little bit of a line when you start talking about the other attorney's ethics. But he felt completely fine and confident doing that. See it right here. All right, let's move on. On May 8th, 2024, Mr. Cosgrove, to his credit, acknowledged that Mr. Mello impeded progress on discovery. He provided some discovery to the defense, although none of it related to Ms. Peters' interactions with Mr. Mello and Tully. So he provided some discovery, but still they don't have any discovery about any interactions or statements with Catherine Peter. On July 10th, 2024, in response to the defense's March 19th, 2024 demand, Mr. Cosgrove stated that the Commonwealth would provide all evidence required under Rule 14 and recognize its obligation to provide exculpatory evidence. Beginning in the fall of 2024, the defense made a series of specific demands for favorable and discoverable evidence pursuant to Brady Giglio and Rule 14. Many of these specific demands sought evidence related to Ms. Peters' relationship with the Commonwealth. They want to know what the relationship is between Kate Peter and the Commonwealth. They have to know that. They are entitled to know that. She was part of this prosecution. She was investigating for them, providing them information. They are entitled to any sort of documents, emails, text messages, phone logs, anything that has to do with Kate Peter and the Commonwealth. Until July 2025, the Commonwealth didn't disclose any evidence responsive to the defense demands for evidence related to Ms. Peters' relationships. You understand this? This is July 2025. When I think, what was it? The automatic discovery was the discovery was due in like a year before, and they made many demands for this. So until July 2025, just a couple months ago, they didn't disclose any evidence relating to Ms. Peter. Although the Commonwealth has provided some materials related to Ms. Peter, so eventually they did, their production to date has been woefully inadequate. The Commonwealth has represented that certain evidence provided by Ms. Peter to Mr. Mello and Tully in 2023 is no longer in their possession, custody, and control, and has since been deleted on information and belief on Ms. Peter. Okay, that's a very important part, because if they could have obtained that information, and they can't get it anymore, that you can't just wash your hands and say, well, guess what? It's not in our possession, custody, control anymore, so therefore we're free of our Rule 14 obligations. No, you're not free of them. Once you have those obligations, they continue with you. And if because of your negligence, you didn't obtain that, which is what you're required to do if you're the prosecutor, definitely if it's Brady and Giglio, which it is in this case, obviously any of those emails, any of the correspondence between Kate Peter and anybody in the Commonwealth is obviously Brady material, and you didn't do your obligation as a prosecutor to either look into it, or you probably had it. Forget about even looking into it. You have a duty even to look into Brady material, but this is what they had. And now they're saying, well, we don't have it anymore. That's your bad. Sorry. Case dismissed. So if they've lost this information, and a lot of times you have cases where you're making arguments where the prosecution did not turn over Brady material. They didn't turn over Brady material, and you make arguments to the judge. Look, and it's real Brady material. It's not just like a defense attorney's smart argument. It's real Brady material. And then the judge will just tell you, okay, well, you have it now? Okay, fine. So let's go on. Or you want a continuance? Okay, so we'll give you a continuance, but now that you have the Brady material, we'll give you some more time, or maybe we'll have some other remedy. They don't dismiss the case. But if there was not Brady material that was turned over and now it doesn't exist anymore, then of course the case has to be dismissed. Although the undisclosed evidence indisputably was in their possession, custody, and control, the Commonwealth regrettably has taken the position that they are not obligated to disclose the evidence because it is no longer in its possession, custody, and control. The exact argument that I just talked to you about. The court should soundly reject this weak justification for the Commonwealth's failure to preserve and provide exculpatory and/or discoverable evidence to the defense. See Commonwealth versus Woodward. There's probably many more cases like that. On September 12th, 2024, I sent a specific demand to Misters Cosgrove and Mello in which the defense sought from the Commonwealth any information in their possession, custody, or control that tended to impair the credibility of any possible witnesses against Mr. Carney, and all promises, rewards, or inducements made to any possible witnesses against Mr. Carney. This demand included information related to Ms. Peter and Tully. In this demand, and again, Tully is a witness also, right? So Tully's going to be a witness. Even want to say that Peter's not a witness, but Tully is a witness, and any correspondence and any information that he has is going to be included in this demand, which would include all the emails and all the links and anything that Kate Peter sent him. In this demand, I detailed Ms. Peters' prominent role in a conspiracy created in December 2023, the purpose of which was to lure Mr. Carney into being charged with witness intimidation of Ms. Gattani after Tully served her with a grand jury summons issued by Mr. Mello. Mr. Mello's direct involvement in this scheme was so great that it resulted in the court disqualifying him from the prosecution of the 2024 indictment in which Ms. Gattani is the alleged victim. So because of this, and this is, if you want to look at the link to the opinion, this is the opinion where Mello was disqualified from being being part of the prosecution in that indictment against Ms. Gattani, the alleged victim. So when you as a prosecutor get too involved with the witnesses, you become a witness. And that's what happened in Gattani's case. I informed the DA that an extraction report from Ms. Gattani's cellular phone provided to the defense appeared to have scrubbed communications from Ms. Peter, Mr. Mello, and Tully after Ms. Gattani and Ms. Peter discussed something which is blocked out. Now take a look at this. Take a look at this footnote. Ms. Gattani has since filed lawsuits against Mr. Cosgrove and Tully, as you may have become familiar with that lawsuit that she filed in pro per by herself, not being represented by any lawyer, which is always a good idea. For what she alleges are their improper actions in the 2024 indictments, including intentionally causing her emotional harm. She also sent a demand letter to Morrissey in which she strongly implied her intent to sue the DA for at least $50,000 unless she is financially compensated soon. In addition to further sabotaging her own credibility, Ms. Gattani virtually unprecedented scorched earth, blame everyone legal maneuvers have created an irreconcilable conflict that requires Mr. Cosgrove and Tully immediate disqualification from the 2024 indictments and possibly the 2023 indictments. So now they are being sued. So Tully and Cosgrove are being sued now, or about to be sued. Well, Tully was already named. What does it say here? The lawsuit is against Cosgrove and Tully, but she's also planning on suing the DA. In case you haven't seen this, let me just pull this up for you. Okay, this is Lindsay Gattani's letter. All right, Lindsay Gattani to Michael Morrissey. Dear District Attorney Morrissey, pursuant to that statute, I hereby present the claim on behalf of myself, Lindsay Gattani, a resident of Norfolk County of Massachusetts, against the Norfolk County District Attorney's Office and its employee, Special Prosecutor Robert Cosgrove, for damages arising from tortious conduct related to the mishandling and unauthorized disclosure of Ms. Gattani's confidential sexual assault report. Nature of the claim: on or about August 8, 2024, and continuing thereafter, Special Prosecutor Cosgrove, acting under color of law, failed to protect the confidentiality of Ms. Gattani's sexual assault report, provided in connection with an October 2023 assault by Ian Carney. The report was improperly disclosed to Carney, a defendant in related criminal cases, and published in unredacted form by Carney and Jason Broyles, inciting widespread harassment. So you are not supposed to turn over this confidential information, which is why there's another lawsuit now. Cosgrove's actions and omissions, including his role in the investigation and coordination with Massachusetts State Police Lieutenant Tully and Medfield Police Detective Dylan Haldeman, constitute intentional infliction of emotional distress, negligent infliction of emotional distress, invasion of privacy, abuse of process, violation of Massachusetts Civil Rights Act, breach of statutory duty, negligence per se. The claim arose on about August 8, 2024, when the unredacted report was disclosed and published with ongoing harm due to continued harassment. The event occurred in Norfolk County, Massachusetts, during investigations related to Carney's criminal cases. Damages: Ms. Gattani suffered severe emotional distress, requiring therapy. Okay, this is not just emotional distress where she just pops a few pills. She actually required therapy. Reputational damage, including fear that law enforcement will not believe her future reports. Medical expenses, pain and suffering, and legal expenses. The amount of damages is to be determined at trial, but is estimated to exceed $50,000. That's a lot of money. Okay, and that's what the damages are going to exceed. This is the claimant. Please investigate this claim and contact me to discuss resolution within the 6-month period prescribed by the statute. And I guess if you don't, then you're going to be part of the law. You're going to be part of the lawsuit. So the suggestion here is that she's notifying them before she may have to file a lawsuit. That may be what the statute requires. So now that she's done that, well, now we got a conflict with everyone named in her lawsuit. So they have to be disqualified from the case now. So Cosgrove should be disqualified. Mello has to be disqualified. He's a witness. And now you're going to have Cosgrove also should be disqualified. And Tully. The Commonwealth didn't respond to the specific demand for evidence. They haven't responded yet. They only got 6 months, right? She said, you better get back to me in 6 months. On October 8th, 2024, I sent Mr. Cosgrove and Mello another specific demand. This detailed 15-page demand was entirely devoted to production of exculpatory and discoverable evidence related to Ms. Peter, including. So here's another demand. All evidence, information in whatever form Ms. Peter furnished to the Commonwealth and or Massachusetts State Police involving the investigation or prosecution of Mr. Carney, any records of Ms. Peter's communications with the Commonwealth and MSP. Can't get more clear than that, right? Between October 1st, 2023 and the present, and any documentation or memorialization of statements made by Ms. Peter to the Commonwealth or Massachusetts State Police regarding Mr. Carney in any form, including but not limited to written reports, notes, emails, text messages, audio, or video recordings. I mean, I don't know how you can get more broad than that. We want everything. The Commonwealth didn't respond to the specific demand for evidence. I wonder why. On October 17, 2024, I sent Mr. Cosgrove another specific demand for exculpatory and discoverable evidence. In this demand, much of which related to our recent discovery that D.A. Morrissey improperly conducted official public business from his personal email account. That's another part of this motion, by the way. I mean, there's so many, as I said, there's so many different parts of this motion. I again alerted the Commonwealth to Ms. Peter's direct involvement in this case. Yet again, the Commonwealth didn't respond to the specific demand for the evidence. December 16, 2024, Mr. Mello forwarded some communications. So finally, Mello did forward some communications between himself and Ms. Peter to Mr. Cosgrove. Notwithstanding our prior demands, Mr. Cosgrove didn't supply this evidence to the defense until July 7, 2025. Okay, so stop for a second. December 16th, 2024 is when Mello forwarded some communications between himself and Catherine Peter to Mr. Cosgrove. So that's December 16th, 2024. So how long do you think it would take for Mr. Cosgrove to produce that to the defense in this case? Well, it took them another, 7 months. July 7th, 2025, almost 7 months after he received it. I'm sure there's a good explanation for that. It's probably lost in Proctor's file somewhere. As explained, the untimely disclosed communications between and among Ms. Peter, Mr. Mello, and Tully is critical for the instant motions, and if it had been disclosed promptly, would have been included and supported the defense's first motion to dismiss the indictment. On March 29, 2025, I sent Mr. Cosgrove another specific demand for evidence related to the Commonwealth's relationship with Ms. Peter. Once again, I demanded any evidence, including but not limited to Ms. Peter's involvement in Mr. Carney's case, such as evidence of interactions and communications between and among Ms. Peters and Carney and Reed prosecution teams, which included Mr. Mello, Tully, Sergeant McKinnick, Mr. Proctor, and Lieutenant Fanning, among others. I informed Mr. Cosgrove that it had been more than 5 months since our first specific demand and that the Commonwealth still hadn't disclosed any information or materials in response to our demands. I again provided detailed facts which established there was no doubt that the Commonwealth had in its possession, custody or control, undisclosed materials related to its relationship with Ms. Peter. We know there's more there. We know it's there. You're going to have to turn it over. Or you have to come up with some excuse why you couldn't turn it over. And then, if you didn't turn it over, why that's not an automatic dismissal based on Brady. On July 7, 2025, the Commonwealth disclosed some evidence related to Ms. Peter, including the messages forwarded by Mr. Mello to Mr. Cosgrove on December 16, 2024. So, they did get some messages. So finally, in July 7, 2025, they did get some of the messages that were forwarded that were between Kate Peter and Mello. And a few emails that Ms. Peter sent to Tully without his responses. Well, that looks odd. Did he just not respond to any of the emails? Well, maybe he'll claim that he didn't. The Commonwealth representative turned over 4,727 pages of Detective Tully's emails when, in fact, more than 4,000 of those pages were blank, as we know. On July 12, 2025, I wrote Mr. Cosgrove once again, making a specific demand for all evidence related to Ms. Peter. Since July 12, 2025, the Commonwealth has provided some additional Peter evidence, including a file containing the previously blank Tully emails, while alleging that some of the evidence is no longer in their possession, custody, or control. So they did turn over some, but then they said, well, some of the information is not in our possession, custody, or control. On August 13th, 2025, Mr. Cosgrove represented to the court that Tully has a practice of not clicking on the unsolicited links emailed him, but instead might go himself and look for it online. You don't remember that? Right, Tully, when he's getting an email from Kate Peter, and Kate Peter is attaching a link to Turtleboy's show and with a timestamp or something like that, right? So Tully is not just going to click on that link, because who even knows who Catherine Peter is? To Tully, she's a complete stranger. So what he does is that when anybody sends him an email with a link, then he'll just go and try to find that link online himself, but he won't click on it himself. Mr. Cosgrove further stated that Tully did not review any material sent to him by Miss Peter, which were introduced before the grand jury. For example, Mr. Carney's YouTube presentations that were introduced to the grand jury, all those things that Tully found himself online, he may have been pointed to them by Miss Peter. He may have been pointed to them by multiple sources. They have multiple sources, not just Catherine Peter. Don't think that all they have is Kate Peter. They have multiple sources about where Turtleboy is getting, all this witness intimidation that he's doing. He may have been pointed to them by multiple sources, but he never clicked on whatever it was that was sent. So these were never accessed in effect by the Commonwealth. So what they're saying is, look, we never had possession, custody, control on those links because we never clicked on them. That was Cosgrove's argument. Tully never clicked on those links. And since he never clicked on those links, he didn't know what was there. So he never had that information in his possession, custody, or control. You see how the argument works here? And therefore, you can't fault us and dismiss this case based on Brady violations because Tully never clicked on those links. Who knows where those links led to? Maybe there was some Google Drive somewhere, but now that we click on it, it's gone. So we never had this information in our possession, custody, or control. You see how this works? You see how the argument works? But there's a big, big problem with this argument, which we're going to see soon. If the links are now dead, and this is continuing with what Cosgrove said, if the links are now dead, we've never seen them. The links are presumably dead because whoever sent them took them off of the internet. If Tully had clicked on the link, it would have taken him somewhere. Probably would, but he didn't. Tully never clicked on those links because who in the world to him is Catherine Peter? Why would he click on those links? He doesn't know this woman. There is strong reason to doubt the truthfulness of Tully's claim to Mr. Cosgrove, if we haven't made that clear yet. November 20, where we are. Tully swore. So you have the exhibits here where you have Catherine Peter forwarding a recording to the MSP in a private link. And then you have a transcript where Tully swore that she provided the audio recording to him in a private link. So he's saying that he provided him in the private link, not that you went and got the video on some by looking up Turtleboy's channel yourself. So there's reasons to doubt whether that's what actually Tully did. That's the first argument here. Sergeant McKenna informed Tully and others that he had already provided something blank to ADA Lally. But even if Tully didn't personally review any links sent to him by Miss Peter, Mr. Cosgrove's representation that the Commonwealth in effect never accessed the links provided to them by Miss Peter ignores indisputable proof that Mr. Mello accessed the materials Miss Peter provided to him. Mello did access those materials. So even if you want to say, well, Tully never accessed those materials, so he never clicked on those links, so they're not in our possession, custody, or control. Well, here's the problem. The problem is that Mello did. Mello did access those materials. And if Mello accessed those materials, guess what? It was in his possession, custody, or control. And if it was, he's got to turn it over. And if he didn't, and now it's gone, that is textbook basis for a Brady violation that requires a dismissal. How are they going to get around that? How is Mello going to be able to say now that he had never accessed the materials? And they have their receipts here. See the exhibits. Once the links were sent by Ms. Peter and received by any agent of the Commonwealth in 2023, that evidence was in the Commonwealth's possession, custody, and control, and was obligated to disclose the evidence to the defense under Brady, Giglio, and the pre-existing Rule 14. And now we get into Mr. Mello being a material defense witness. The court already has disqualified Mr. Mello from Mr. Carney's 2024 indictment. If you case, the court forgot about that part, right? In the Gattani case, the alleged victim, because he made himself a material defense witness. Mr. Mello's interactions and communication with Tully and Ms. Peter and his conduct before the grand jury has made him an essential defense witness. Mr. Mello's direct advocacy in seeking to have criminal charges lodged against other individuals while acting as both an advocate for witness Chris Albert and his official capacity as Mr. Carney's prosecutor creates an actual conflict of interest, makes him a material witness, and compels his disqualification. Now, what he spoke you guys all remember this probably, that Mello was the one who called about the violent protesters, very scary 4 women who were holding a sign outside of D&E Pizza at one point, and urged them to be arrested. That's recorded. You can go find it. This is actually a link in this motion. I think it actually links to the Young Jerks, and they've got this recording. Well, anyway, by doing that, you're now becoming a witness, and you're inserting yourself into the investigation. So guess what? You have to be disqualified. On November 5th, 2023, weeks after Mr. Carney had been arrested, Mr. Mello called the police on behalf of Chris Albert. There's the link right there. That's just so awesome about this motion. You just click on this link and it brings it up. But I don't have 4 hours to go through all the links now and play them for you. Maybe we're going to have to continue this another time. But that, if you just click on that link, it takes you to that call. And he said that he's a special prosecutor. He was a special prosecutor for Turtleboy. And he said that, my reading of the statute is that they're committing witness intimidation and they should be arrested, because the officer actually gave him some pushback. We'll see if they talk about it. Who already was a named witness against Mr. Carney. To report these people were picketing Mr. Albert across the street from his Canton pizza shop. In his call to police, Mr. Mello initially identified himself as prosecutor with the Norfolk DA's office. He immediately asked to speak to the supervising sergeant. Mr. Mello reported a protest. This protest occurring near Mr. Albert's pizza shop and requested that the police car respond to make sure they are not intimidating. Okay. After Mr. Mello was asked to confirm his identity, he abruptly disclosed that he was not a Norfolk County prosecutor, but the special prosecutor at Aidan Carney. So then he said, no, I'm a Norfolk County prosecutor. And they said, no, I'm just a special prosecutor on Aidan Carney. And there's so much stuff. There's also stuff about how, why in the world will Mello be chosen as a special prosecutor in this case? And you see his bills in this case. You see the bills that are attached to this motion, what he's getting paid. Okay. Not surprisingly, after hanging up with Mr. Mello, the officer who took the call properly noted to the fellow officer, well, they can protest. This is America after all, right? Maybe not in Massachusetts. I'm not sure. An officer called Mr. Mello. We'll see what the First Amendment means in Massachusetts soon. An officer called Mr. Mello back and told him that the incident amounted to nothing. It was nothing more than 4 people holding signs across the street from D&E Pizza who weren't impeding traffic. What do you want from them? The officer noted it seemed kind of mellow. It's a small group now. Undeterred from his advocacy for Mr. Albert, Mr. Mello asked the sergeant to look at Section 29. Why don't you look at Section 268, 13A, which I know by heart, by the way. After reviewing the witness intimidation statute, the sergeant asked Mr. Mello what he was thinking of doing. Mr. Mello urged the Canton police to either charge or disperse them because they met every single requirement of that statute. According to Mr. Mello, these protesters were certainly there to influence Mr. Albert or whatever else the statute states. They aren't there for any other reason. Mr. Mello's conduct and his credibility will be key issues at trial, and it would therefore be improper for him to advocate for the Commonwealth as an unsworn witness. Mr. Mello must be disqualified pursuant to the witness advocate rule as codified in Rule 3.7, which mandates that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. Right. That's obvious. A lawyer can never be witness. Everybody knows that. So he's a witness now. Mello's got to be disqualified. The need for evidentiary hearing. So they basically lays out the fact that even if you don't want to dismiss this case outright, which there is some really, really strong basis to dismiss this case outright, still, at the very very least, you should have an evidentiary hearing and get Mello on the stand. Get everybody on the stand. So that's where he kind of leaves it off. Let me just take a see what we have here. We have Trish. Thank you very much for that super sticker, $10 from Trish. And let's see what we have here. Hello from Brussels. Thank you for your clear analysis. The corruption in Massachusetts is terrifying. By the way, thank you for the super sticker here, programmer. I'm hoping you can recommend a local lawyer for a French friend who stupidly bought a house in Detroit 8 years ago. Shady management company. Well, all you got to do if you have any sort of legal question, you can send it to me at brothercounsel99@gmail.com. You send it there, and we will get it to the people. Either we'll handle it or we'll get it to the right people who can handle it if it's a question. I mean, if it's a case or not. So remember, I mean, if you have any questions, you can put them in the chat now. But we're going to have to continue this another day. I mean, I know this is fun. We're having a lot of fun here. But there's so much more to unpack in this motion. I mean, really, we're just getting into it. Like, this is a significant part of it. Like, this is a good part of it. But you saw we started from like paragraph like 268, and there's a lot more here. I mean, there's so much. It's really, really an interesting read, and that's what I did most of the day today. So I'm happy to present it to you. But I will remind everybody that even though there was a request for an evidentiary hearing in Karen Reed's case, which I think everyone would agree to, I see people in the chat saying, no, we got to continue. But remember, in that case, in the Karen Reed case, there was no evidentiary hearing held, despite the major questions, which in that opinion, Judge Cannoni was saying how many things we don't know. Like, her entire opinion was all about all the things that we don't know, but presumably this and maybe that and maybe this other thing. And, who knows, for reasons that were undisclosed or reasons that we don't know, why Trooper Proctor kept those things. I should say former Trooper Proctor, or as Mark Beddoe says in the motion, disgraced former Trooper Proctor. Why was in his file for so long? We don't know those reasons, but we definitely don't need an evidentiary hearing. That was essentially Judge Cannoni's point. But I mean, look, at the very least, you got to have an evidentiary hearing, and just on what we read today. And this is not even scratching the surface. There's much more to go here. So maybe we'll do this again tomorrow. But I think that's going to be it for today, because I mean, this is a lot to digest just in itself. I think I don't want to overload everybody with information, and it's good to take it maybe a little piecemeal. And let me see what we have here. Brother Counsel, do you know when defense got access to the grand jury stuff? I'm assuming recently, because I don't recall the grand jury stuff in last motion to dismiss, but bad memory. Yeah, I don't know. They didn't say exactly when they got the grand jury information. Understanding how compliant the Commonwealth was so far with all of their discovery production, I would assume they got it pretty recently, But yeah. Let me see what else we have here. Melanie Little did like a 5-hour stream earlier talking about it. Yeah, I know. I mean, you can go 5 hours, but I got started a little bit late today. Maybe if I start at 10 a.m., I can go the whole day. But it's there's other things to do also. So I love you guys and everything, but I think for today we're going to have to cut it out there, and we'll take the next portion of it maybe tomorrow. Okay, maybe tomorrow we'll do. So maybe just rewatch this a few times, and then we'll get to see what tomorrow. Brother Counsel, should we expect to see a written response to this from Cosgrove? Of course you have to. They're going to have to file some sort of response. They're not going to let this go unresponded to. Yeah, they are going to respond to this. BC, are you close to Wayne State? I'm about 20-minute drive. That's where I went to law school, Wayne State Law School. By the way, everybody, don't remember what Tear Dad said. Like button needs to be hit. That's true. Jane says, your grand bro, we love you. We'll wait. Maybe we'll do it tomorrow. I'll see if I can get this. Maybe we'll do some of this tomorrow. Maybe like tomorrow afternoon after hockey, because I'm supposed to be playing hockey tomorrow. Costco's official response, so what? I mean, this is just a masterpiece. They I meant it when I said that this is a masterpiece. I'm visiting Michigan tomorrow. Great place to visit. Went to Wayne State. So did I. We'll be here for you. You're the best, BC. Thank you very much. Deborah, great review. Love your commentary. Yes, please, for tomorrow. Dave says, Melanie did 5 hours and only covered the memorandum of law and 22 pages of the affidavit. I mean, there's a lot to go through. I mean, really, and there's so much to go through here. We didn't even touch on the memorandum of law. I kind of spoke out some of the basis and some of the law, but yeah, there's a lot to go through. Costco will ask for 3 months to respond to it, probably. not a bad guess right there. All right, so everyone, keep your eyes peeled. I think I'm going to try to do a tomorrow stream at maybe like in the afternoon sometime. Just look at this. Fan for the truth. I was across the street from D&E Pizza today. Brought my friend visiting from Florida. Took a picture of her with D&E and CF McCarthy's in the background. Told her she was now a Turtleboy Freedom Rider. You know what else she was? She was guilty of intimidating a witness. Because that's what happens when you stand across from D&E Pizza and take a picture. The affidavit is 88 pages, I know. And we didn't go through all 88 pages right now. Appreciate your coverage and legal perspective. Thanks, BC. Do we think Costco's reply will have cool links? Oh, no, he's not going to have. I mean, this is just, it's so cool. Like when you have someone like Betterow and his firm putting together a response like this. We've seen the filings from Massachusetts. I mean, we've seen even when Hank Brennan was on the case, he didn't have these cool links. And by the way, if I may say that the font here is really cool also. This is a great font. I'm going to start using this font in my own pleadings. It's a great font, easy to read. He also does a 4-point, not 12-point. So it's easy to read that way. Don't want to forget about Olivia. Olivia's amazing for all she did on the filing. Guess whatever Olivia did. Good job, Olivia. I don't know what everybody did on the file, but yeah. Okay, so keep your eyes peeled for the stream tomorrow. We'll probably get through more of this tomorrow, and we're gonna cut it here because I have other stuff to do. I got other stuff. But we'll pick this up hopefully tomorrow. Okay. Thank you all for joining us today. And by the way, yeah. Okay. So we'll go through this tomorrow. And thank you all for joining. See ya. Laters.